personal liberty. Want to just do that one? Which one's the personal liberty?
I said Meyer, Pierce, and Buck.
Meyer, Pierce, and Buck is correct. Now, Buck is the only case where I don't see any obvious economic claim. Right? This is about mandatory sort of sterilization. But without question, Meyer and Pierce were about the personal liberty claims. Okay. Now, why do I create this sort of distinction? Let me go back to the this video that I showed you all who were here yesterday, and if you weren't here yesterday, I'll see it now for the first time, or maybe not the first time. Right? These cases decided in the early 19 teens and 20s are still discussed today in modern Supreme Court cases, but they're viewed in different ways. For the most part, the economic liberty cases like Lochner and Atkins have been overruled, if not expressly, impliedly. The only economic liberty case in that period that has not been overruled is Muller. Why? Muller upheld the wage law for women. Now they said women are inferior. They are weaker. Well, isn't that what the court said in West Coast Hotel? That women deserve to have this extra protection because of their inferiority. So really, Muller is viewed as kind of this enlightened decision that is still part of the good law. What about Meyer and Pierce, right? Aren't these just substantive due process cases? Well, yes and no. The Supreme Court has sort of reimagined Meyer and Pierce as First Amendment cases, nothing religion and speech. So the court, again, you'll see this later, basically kind of pretends Lochner never happened, right? Pretends these cases just didn't happen. If you actually read Meyer and Pierce, which you've all done, at least I hope you've done, you'll see the difference. Buchanan's kind of this outlier, but this is viewed now as a case about race, even though it wasn't a case about race at the court. It wasn't really an equal protection issue. And of course, as I mentioned, what people kind of upset at me last class, well, not upset at me, but they were upset in general, how can Buck v. Bell still be good law? The courts have cited it favorably over the years. They will not cite Lochner favorably. God forbid, bread, right? But they'll cite Buck v. Bell favorably. Fallopian tubes, just priorities, I suppose. And this is, I like this sort of chart because it sort of lays out where all these cases we just studied, all 7 of them, sort of fall. Does everyone get where these 7 cases started off and where they sort of exist today? Everyone okay with this? Yeah? All right, good. All right, so now I want to go to a question number 3. I'll ask this one for the poll also. Okay, I never stopped that one. I'm sorry. Let's do question number 3. So of these 7 cases, which ones involved a presumption of liberty? Of these 7 cases, which one involved a presumption of liberty? Oh, by the way, before I forget, please email me for credit if you've watched the lecture from yesterday. If you haven't done it yet, please do so as soon as possible. We will keep moving along, and you need to know that stuff. But 15 of you have actually done so already. Okay, so which one of these cases applied a presumption of liberty? Sports Center?
Yes.
Okay. What happened? It's an alert?
Let me see.
What breaking news is there? 11 o'clock in the morning.
It's just updates on some teams.
Oh, okay. Yes.
Nothing breaking.
Nothing breaking. ESPN used to actually have a phone service. It was actually like an ESPN phone. You could buy that back in the day. And the innovation was we got instant alerts. This is back in 2005 or 6 when people didn't even have iPhones yet. Remember those dark old days? No, you don't. Whoever actually owned a flip phone here? How many of you actually owned a flip phone? Wow, look at you guys. Good for you. I'm impressed. Okay, good. T9, you remember how to do that? Yeah, okay. No, she knows what I'm talking about. Okay. All right. Who am I up to? Sir, what's your answer? By the way, what's the presumption of liberty? How do you answer the question then? I'm going to skip you. Alexandra, what's presumption of liberty? No. Quite the opposite. What's presumption of liberty, Alexandra? Try again. Taylor?
I think the presumption, I know that the burden comes to the government to prove that the law is valid.
Correct. So do they presume the law is valid or they presume the law is invalid?
They presume the law is invalid.
Correct. With a presumption of liberty, the court presumes the individual wins. The court presumes the law is invalid. What happens with the presumption of liberty? The court places the burden where? With the presumption of liberty, the court places the burden on the government. And the government must show the law is reasonable. The government must defend their law. The opposite of the presumption of liberty is what we might call presumption of constitutionality. We'll be talking about that today. Or with the presumption of constitutionality, you presume just the opposite. You presume the law is valid and the burden is placed on the challenger, on the person challenging the law to doubt its reasonableness. I almost said reasonability. That's not a word. All right. So Shreya, which of these cases apply to presumption of liberty?
I said Lochner, Atkins, Meyer, and Pierce.
You said Lochner, Atkins, Meyer, and Pierce. What about Mueller? Did that apply presumption of liberty?
I think it was presumption of constitutionality.
How about Buck v. Bell?
Also presumption of constitutionality.
Why do you say that?
For Mueller, the court upheld the regulation.
Oh, they did. You're right about that.
With reference to the state's interest in protecting the women's health.
Let me ask you, Shreya, what was the major piece of litigation, the major brief that was filed in that case? Remember what it was called? Juliana, you got it?
It was the brief, like the Brandeis brief.
Yeah, the Brandeis brief. What did the Brandeis brief say?
I think it was like
Remember-
talking about the difference between men and women and how men are superior.
And who did Brandeis file a brief on behalf of, Juliana?
Was it?
Who did Brandeis represent? Did you represent the woman?
No.
Mueller? Who do you represent? It's not Mueller. Who do you represent?
It was the.
Who are the two parties?
Oregon.
Oregon, yeah. So wait a minute. Was this a case where the government was providing evidence to defend their law? Yeah. So what do you call that, Juliana?
The presumption of constitutionality.
Which one is it?
Liberty.
Yeah. Why?
Because
Who had the burden here? Correct. This is a very common error. And Shreya, you made a very common mistake. I'm not mad at you because half people in this room always have the same thing, right? Just because you apply a presumption of liberty doesn't mean the government can't win. The government can win with presumption of liberty. How? By providing evidence. That was the point of the Brandeis brief. Here is evidence that this law is reasonable. These poor women in their inferior bodies, right? We need to protect them. Don't laugh. That was the evidence. And the court said, you know what? That's not evidence. You met your burden. There's kind of like a myth that during the Lochner era, every single law was declared unconstitutional. And that's simply just not the case, right? It isn't true. What the court said, though, is that the government, you want to defend your law, you must provide evidence. You must defend your law. And that was the thrust of the Brandeis brief. It was all junk nonsense, right? It was all, garbage in the brief, whatever. That didn't matter. They had some evidence to defend the law. It was not the job of Mueller, the women, to say the law is unreasonable. It was the job of Oregon to defend their wage and hour law. Everyone get that distinction. So Mueller was an application of the presumption of liberty. Oscar, did your hand go up? I think.
Yeah, my question was that presumption of liberty was all the cases before Gorman, right?
Oh, you just killed my question. I'll ask you. What Buck v. Bell? Was Buck v. Bell presumption of liberty or presumption of constitutionality?
I think it was presumption of liberty,
Wait a minute. Hold on. How could it be? The fallopian tube case is liberty? Oscar, how could that be?
right?
How could that be?
I'm not really too sure.
You want to take a stab at it? Or a cut, maybe? Yeah.
Is it because it's unenumerated, so the
presumption of liberty doesn't apply?
You're not onto footnote 4. You're still early. You're right in like 30 years.
Never mind, then I don't know.
How could it be, Conrad?
Because they did provide evidence.
Oh, they did, didn't they?
Yeah.
What was the evidence?
It was her parents, like the 3 generations thing, yeah.
Remember the family tree I showed you in class? The 3 generations imbeciles are enough? That's your evidence. So what the court, which even Justice Holmes didn't disagree with sort of the basic mode of reasoning. What Justice Holmes said is, let's analyze the substance of the law. We have all this evidence from the government saying that heredity, imbecility can be passed on through genes, heredity, right? And the way to have our society to be clean and purified from these awful people is to make them unable to reproduce. This wasn't Carrie Buck. She didn't have the job to say that this law is unreasonable. It was the job of Virginia for the government, the colony, to defend the regime. Everyone noticed that. So the answer to this one, number 7, all the above. How you got that one? Just curious. Yeah. The answer to all the above. This is not well understood, and Oscar's correct. All these cases before 1930, plus or minus a few years, were in the sort of the Lochner era. The court applied the presumption of constitutionality. Don't believe me? I got a graph for that. I know this is perhaps a little tricky to see, but it's in your materials as well. Right? Lochner, Mueller, Buchanan, and Atkins. All of these cases from the before 1930, Buck would be in there also, followed what they call a presumption of liberty. Now, we call this a rebuttable presumption of liberty. Rebuttable. Angelica, what does rebuttable mean? I'm sorry?
You can dispute it.
Correct. Who can dispute it?
Well, the rebuttal was, I guess, the person who was bringing the lawsuit.
Well, if there's a presumption of liberty, who has the burden? And so what does the government do to that presumption?
Oh, right.
Correct. The government rebuts the presumption. In other words, the court says, we presume the law is not valid, and the government must show otherwise. The government must show that it is valid. The government rebuts the presumption of constitutionality. Stephen?
I was wondering where the Pierce v. Society of Sisters, Myers, Nebraska is on the list.
It's there. It's you can't see it's really small between those columns. I couldn't fit everything on a piece of paper. Meyer and Pierce fit squarely within the Buchanan and Atkins framework. In fact, Meyer was 1922? Might be up from the year. Yeah, Meyer was 1920. Oh, sorry, Meyer was 1923, and Atkins was 1923. So these cases were decided the same year, and the court's applying the same framework. Yeah, I can't fit everything on one chart, so they're not there, but just pretend they're pink. Other questions? Yes, ma'am.
So Holmes wrote the Buck opinion, but he's generally in favor of a presumption of constitutionality.
You're right, but he has the majority there. It's not in dissent. And sometimes when you are a Supreme Court justice and you are writing majority opinion, you must apply a methodology that all of your colleagues will agree upon. Which is why, again, he used such harsh and violent language, because he was trying to say, yeah, I'm going to do what you're saying, but I'm going to just, call this woman an imbecile and say that she's, promiscuous, in my opinion. Everyone with me? So the first 30 years of the 20th century, between Lochner and Atkins, really, and really going up to Buck v. Bell, the court applied this rebuttable presumption of liberty. Now, as Oscar said, things would change slowly at first. So there are 3 cases we'll study today. Actually, there's a lot of cases today. But the 3 cases we'll be doing first today: O'Gorman, the insurance case; Nebbia, the milk case. I like Leo Nebbia because I think he'd be my friend. I like that kind of guy. And West Coast Hotel v. Parrish. West Coast Hotel is probably one of the most important cases of the 20th century. that you've never heard of. But those three cases represented a shift in how the court reviews laws under the Due Process Clause. Whereas the earlier cases, Lochner, Mueller, and so on, had presumption of liberty, O'Gorman has a different direction. And who wrote O'Gorman? Justice Brandeis. The same guy who wrote those briefs is now in charge. It's good to be the king, right? And what Brandeis basically says in O'Gorman, we'll get to the details in a minute, is we're not going to do this presumption of liberty anymore. We're going to presume the law is valid. And who has a burden now? The people challenging the law. In Nebbia, with the price control for the milk, they didn't presume the law was invalid, just quite the opposite. They presumed the law was valid. And West Coast Hotel is like the crowning achievement of the New Deal court. With the overrule Atkins, and they basically overrule Lochner. They don't say that, but Lochner's basically overruled. But in all these cases, there's what they call a rebuttable presumption of constitutionality. In other words, they presume the law is valid unless the challenger can bring enough evidence for it to show otherwise. To show that the insurance contract is unreasonable. To show that the milk price control is unreasonable. To show that the minimum wage for women is unreasonable. But then we get to the green one, which is the United States against Carolene Products, another very important case. This is what Laura was hinting at before. Anna was hinting at before. All right. Carolene Products sort of steps back and says, well, do we have presumption of constitutionality in some cases but not others? Right? If there's speech involved or the political process involved or something else, we'll be a little bit more aggressive, a little more stringent review. And that was the rule in 1938. But then eventually we get to the blue one. The last case for today, Lee Optical, the eyeglasses case, 1955. This was a case where the court basically said, we are out. We are no longer in the business of reviewing laws. We don't care how much evidence you provide the law might be invalid, unreasonable. We don't care. We're not even going to listen to it. If the law might be valid, that's good enough for us. So we see here the sweep of 50 years from Lochner to from Lochner to Lee Optical is the shift in how the court assigns burdens and how heavy that burden has to be. In the Lochner cases, the burden was on the government to defend their law. In the O'Gorman line of cases leading to West Coast Hotel, the burden shifted to the challenger. Carolene Products creates some carve-outs that in some cases you still don't apply a presumption of constitutionality. But Lee Optical said for these economic cases, there's no evidence you can provide that will win. The government will win in almost every case. The fact that the law passes the legislature is enough. And just I want to think about Lochner for a minute, right? This was a Lochner era. Justice Peckham. The presumption of constitutionality is who? Harlan, right? The Harlan dissent becomes prevailing mode for these yellow cases. But who got the last laugh? Oliver Wendell Holmes. Lee Optical, the coup de grace, adopts Justice Holmes's dissent in the Lochner case. So this entire sweep is basically Lochner's played out. You start off with a Lochner majority, and then you go to the Justice Harlan dissent, and eventually you wind up with the Justice Holmes dissent. And that's where we are today. For economic cases today, and I think 8 of the 9 justices, probably all 9 of them agree on this one, you apply the Lochner approach from Justice Holmes. Right? For economic challenges today, good luck winning. There are rare exceptions. Some judges actually accept economic liberty challenges. They're very rare, but they're hard to win. But for personal rights, for rights based on the First Amendment, you still provide a presumption of liberty. So Lochner survives to this day for certain kinds of personal claims. But Lochner is dead for economic claims. This is why we're still talking about the stupid bakery case 120 years later. It's such an important case that was so unimportant at the time. No one even realized what would happen. Study this chart for quite a bit. And also keep in mind the y-axis. Who has the burden? By the way, these graphs are not arbitrarily sized. There's thought here. If you look over here, it says the law is reasonable. For these red ones, the government has the burden to show the law is reasonable. Individual, with presumption of constitutionality. The individual must show the law is unreasonable. And like the bottom, you have a conceivable basis of standards. There's any conceivable basis in which the law can be upheld will be upheld. You can't win that standard. So there's a lot packed in this graph. And Steve and I apologize. We omitted some cases. I do apologize. But we only can fit so much in a single screen. My apologies to Stephen Hawking for the brief history of time. Okay. Randy and I had so many arguments about this one graph. We spent like weeks on this one graph. I think we finally agreed to it. Anyway. Okay. Questions? All right. So I'm not going to go over Lochner, Muller, Nebbia, and Buchanan, Atkins again. I did those already yesterday. Go watch the video, please, if you haven't. I want to start today's class with O'Gorman, which is a case that I promise you is in no other common law case book because no one cares about it. In fact, I didn't even know it existed until Randy told me about it, but it's important. Okay. Who am I up to? Oh, no, not you. Abdullah, can I call on you? Do you have O'Gorman, please?
I'm not ready for that.
Zoe? Please, give me the fact. It's short. It's only a couple pages.
Yeah, so this was a New Jersey statute that established a uniform scale for commissions for insurance agents, unlike how they were payable. And then the insurance agents challenged that the 14th Amendment constitutionality.
Right. So what was the insurance? What was the commission rate in this case? Do you remember? What were they charging? How much? That seems high, doesn't it?
Yeah, a little bit.
That's a high rate. And did the customer want to pay it?
No.
Because what did the law say?
They said that it was unreasonable and could not be paid.
Right. So what's interesting is that this wasn't actually a challenge to the statute directly. It's not like some salesman went to court and said, "Oh, this statute's unconstitutional," right? Instead, you have a breach, right? Breach of contract between a salesman and an insurance company. And the salesman said, "I want a 25% commission." The insurance company said, "That's way too high. We're not going to pay it." Usually, if there's a breach, you just resolve it. You figure out, what the liability is. But here, there's a statute saying this commission itself might be unreasonable. All right, Oscar, I think you're next. Yeah, do you have O'Gorman? So, what did Justice Brandeis hold in O'Gorman?
Essentially, it was like a three-part thing, or two-part thing.
Sure.
Essentially, it was the need to meet the ends because the needs were to avoid evils of unreasonably high rate levels. The state commission may limit commissions. And New Jersey statute was clearly within the scope of police power, which was the fit, right? And then it was the business of insurance so far affected with the public interest that the state may regulate it.
Okay, good. Yeah, thank you so much for that, Oscar. So, what Justice Brandeis does is he basically shifts the presumption. In the earlier cases, the presumption was one of liberty. That is, the government had the burden. Oscar, does New Jersey have to defend why this law is reasonable? Is there any burden on New Jersey in this case?
Oh, in this case, no.
Yeah. Is New Jersey even a party to this case? Yeah, New Jersey's not even in the case. All the burden is on the person seeking to enforce the commission, the 25% commission. And Brandeis says, okay, what are the ends? What is the government trying to achieve here? Insurance is important, right? Insurance affects public interest. I mean, why do we have insurance? I mean, because if something bad happens, they'll pay for stuff, right? There's a car accident, right? Or or something else, right? Insurance, in theory, will pay for it. There's a fire, right? So the government says, the court says that having insurance is an important public end. I don't think anyone would disagree with that. So then what is the means? What are they actually doing? They're restricting the commissions that are paid to the insurance companies, or paid by the insurance companies, I should say. Now, Oscar, what is the fit between the means and the ends there? Is there a close relationship between having insurance and limiting the commissions? I'm asking you.
I would say probably not, but
Not
obviously.
really.
I'm different.
Right, I mean,
So,
since the beginning of time, people charge commissions, right? And whether the commission is 10%, 20%, 30%, that's not going to turn the industry upside down, right? If Hartford didn't want to pay a 25% commission, what could they do?
Go find somebody
Go
else.
find a salesman, right? This does not seem like a very necessary law, right? It just seems a way to just sort of stick it to salesmen. If you're a salesman and you sell this insurance and you seek a commission, I mean, there's negotiating bargaining power. You can ask in advance, what's your commission? Oh, 25%, that's too much. I don't want to pay it. Go find someone else. So this doesn't seem like a very useful law. But the court here is deferential. They say, look, the plaintiff in this case, the people challenging the law, haven't really done enough. There are these high rate levels, and the state deems this to be an evil. And the challenger hasn't given us evidence otherwise. So we will uphold the statute as clearly within the scope of New Jersey's police power. What's sort of genius about this decision is how simple it is, right? This is not a complicated case about minimum wages or about, sterilization or schools. It's about an insurance sales contract, right? The most, I don't say mundane, that's not a nice thing to say, but, just pretty routine agreement. Right? And the court upholds it. At the time, people start saying, wait a minute, what's going on? This is not the way that Lochner was decided. Yes, Oscar.
Earlier, whenever we were talking about the rebuttal presumption stuff, you told us to identify with Holmes more from your office?
No, Harlan.
Okay, go ahead.
Brandeis in O'Gorman. In O'Gorman, Justice Brandeis follows the Justice Harlan approach. They're both H, so they get confused, right? There's Justice Harlan, he was the dissenter in Plessy, and there was Justice Holmes. He was the Buck Tudell guy, right? Very different. I don't think they actually liked each other. I'm not even sure. I don't think they did. They seem to be very different walks of life. Holmes was from this patrician, regal family in New England, and Kentucky was from, Harlan's from Kentucky, salt of the earth. Both remarkable judges, both of them. Okay. What's important here is the presumptions flip to one of constitutionality. In theory, at least, you can challenge it, but the challenger doesn't really have much evidence to the contrary. Right? There's a dissent. Right? There's a dissent in O'Gorman. And they're saying, wait a minute, what happened here? Right? Van Devanter. It's like, what happened? This is not consistent with Lochner. Right? This law is not needed. So what changed? Right? Why did this law change? Well, as we've seen in this class several times, when new members of the court are added, opinions turn out differently. The legal tender case is perhaps a prominent example. When President Grant made the paper money appointees, the case flipped in the span of a year. So originally when this case was argued, it went 4-4. They tied. So they re-argued it the following term with a new member of the court. No, not John Roberts, although you're in the ballpark. Owen Roberts. Owen Roberts was a Hoover appointee. And he was a political progressive. Even though he was a Republican nominee, he was a political progressive. And Justice Roberts voted in favor of the presumption of constitutionality. A lot of people think that the New Deal court sort of shifted in 1937 when Roosevelt was in office, but simply not true. President Hoover made 2 appointments, Chief Justice Hughes and Owen Roberts, and those both moved the court to the left. Yes, Trent.
So when you say progressiveness, so assuming it's like the presumption of constitutionality is progressive.
Oh, yeah. Right. The entirety of the progressive movement was experimentation, that the government should be allowed to experiment with different types of laws. And the government can't experiment if the courts are saying things are unconstitutional. So the sort of the approach to the progressives was let the government do what they need to do and defer to them, right? Defer the law is valid. And that's what Justice Roberts and Justice Hughes favored. Justice Brandeis, to be sure. Holmes, we've gone even further, but he takes what he can get. Oscar?
I know this is still a progressive court, but like, in a way, isn't it the New Deal court already?
Not yet. Do you know why?
Because he got rid of all the justices.
No, because there's no Roosevelt yet. What year was this case?
That's what I mean, got rid of all the justices.
No. It's not. It's absolutely not the Roosevelt court. This case came before Roosevelt was even elected. That's why it's important, right? Again, Randy is my colleague. He's sort of unique in focusing on O'Gorman, but it's an important case precisely because Roosevelt had not actually appointed anyone yet, right? This was not a New Deal case. People think it is, but it's 1931, right? Roosevelt did not come to office until 32.
Do you think that part of the reason that it shifted from Lochner here is because the state wasn't a party to the case, so they weren't even there to justify their law?
It's a creative thought. I sort of thought about that before. Not really, because in Nebbia, only a year or two later, they come out the same way, and that was a criminal prosecution. But in theory, at least, what the court could have done is ask New Jersey Attorney General to file a brief defending the law. And this is one of the rubs in Dred Scott, right? The court declared the Missouri Compromise unconstitutional, but the U.S. government wasn't even a party. So it's generally a good idea when you declare a law unconstitutional to have the government's opinion there, and that's often what the court does today. Good question. Any other questions on O'Gorman? Simple case, but very significant. At least Randy thinks it's significant. I agree. Yes, Steve?
So like, I know that they're still not doing the differentiation between personal and economic, but like, I know this case is an economic one, and so I was wondering if that makes a difference yet, if it's personal or economic.
Not yet. With the benefit of hindsight, the answer is yes. But at the time, the court hadn't drawn this distinction yet. That would not come until Carolene products a couple years later. Let's talk about milk. Fidel, Nebbia, please give them the facts.
Yeah, there was, I guess at the time, the price of milk was like going down pretty bad. There was the producers, farmers of milk.
Okay. Hold on. Well, why is it a problem that prices are going down? Isn't that a good thing?
It's good for the people, like bad for like the farmers.
Bad for the farmers. I see. Okay, go on.
And they passed a law that was basically saying the minimum price required for milk. And there was this farmer that basically sold it along the way for almost like double what they charged them to do that.
Right. So during the New Deal, there were all these sorts of experimentations with prices. So we already studied Schechter poultry, which is called the sick chicken law, right? Where you had to take whatever chickens came your way. You couldn't have that. There were also experiments with minimum and maximum prices. Okay. When you set a minimum price, that is basically sort of a subsidy to the sellers, right? You know, in the usual course, sellers compete. So maybe I sell milk for 9 cents a quart and he sells it for 8 cents a quart, right? And okay, I'll go to this guy if he's selling it for cheaper. But when the government sets a minimum price, it eliminates that possibility of competition. You can't compete against others. Was this actually a way to help the dairy farmers? Elizabeth? Did this law, which set a minimum price for the sale of milk, actually help the dairy farmers? You say no, why not?
Well, the Senate already said that the law was actually aiming at the large distributors.
Did any of the money from this law actually go to the dairy farmers? All right, so this is one of the rubs, right? When you set a minimum price for the sale, it clearly helps the people selling it. But it's not clear they pass those savings or those earnings on back to the distributors who make the milk, the farmers. So again, if they say the purpose of this law is to help the dairy farmers, does this law actually help the dairy farmers? Probably not. Okay. I think we're back. Conrad, yeah, you. So you want to give me the facts? I have the thing up here to help with the facts of this case.
Yeah, so what happened is they set the price for milk at like 9 cents, I want to say, whatever.
Right. That was the state. The state set the minimum price for a quart of milk at 9 cents. That's right.
And so then this guy made a deal where it's like if you buy 2, you get 1 free. So if you buy 2 things of milk, he'll give you a side of bread that's worth 5 cents.
Right. So basically, he's taking price off the top. I think this is very creative, right? He's not clearly violating the law. Of course he is, right? But he tried to find a way around the law. So this was actually a criminal prosecution, if you can imagine, for giving away free bread. And he was charged with this, probably in this law. Robbie, what did the court do here? Did the court uphold the New York price control law?
Yes. Just because, like, they kind of determined that the legislature has deemed this evil price gouging.
Yeah.
And this was a reasonable way to limit that.
Could Mr. Nebbia rebut that presumption of constitutionality?
Seemingly no.
No, he could not. He tried,
Yeah.
right? But here they applied a presumption of constitutionality. And the court said the state gets to decide what's in the public welfare, right? And the court found a reasonable fit between the means and the ends, right? What was the end here? Ruthless competition from destroying the wholesale structure on which a farmer depends for his livelihood, right? By selling the milk for so low, you're going to force the dairy farmers to lose their means and to, not be able to feed their children. I don't know what, right? And the court basically said this was not unreasonable. It's true, as Elizabeth said a moment ago, this money doesn't actually go to the dairy farmers. They thought, well, maybe if the producers have more money, they'll give money to the dairy farmers. Maybe yes, maybe no, but we're not going to look at it so closely. There's going to be some evidence to support this law's reasonableness, and Mr. Nebbia can't dispute that. Therefore, the law is upheld. This was an easy case for the court with presumption of liberty. Presumption of constitutionality, right? If there's a presumption of liberty, then you have to ask, is this money actually going to the farmers? Yes or no? But with the presumption of constitutionality under O'Gorman, this is a simple case. Any questions to the majority? Now, the 4 dissenters were a block. Where do I have the picture? So these are the 4 horsemen, as they were called. Justice Van Deventer, Justice Sutherland, Butler, McReynolds. These are the 4 conservatives who vote together as a block. They were called the 4 horsemen, if you remember your Bible, after the book of Revelation, 4 horsemen of the apocalypse. I think I'm one of them. These were the sort of conservatives who would come across and say every single law was unconstitutional. But again, the swing vote was Justice Owen Roberts, who found here with the presumption of constitutionality, this law was reasonable. All right. Questions on Nebbia?
Can we go back to their photos again?
You don't like this one?
That was pretty good too.
Sure. How's that? Good? What do you think? Do they look like horsemen? No. Sutherland kind of does? Why? The mustache? All right.
Yeah.
That's it.
Did they vote as a block in O'Gorman?
Yeah, they did. Yeah. They voted block consistently through West Coast Hotel. All right. So now I want to sort of bring you back to the first half of the semester when we studied the magical year of 1936. Right? What was going on? Where's my timeline? What was going on in the court in the 1930s? What cases did we study? Well, remember we had Schechter Poultry. We had NLRB versus Jones and Laughlin Steel. We had Wickard v. Filbert. Remember those? You should. Around the same time that we have the Lochner era, where the court is scrutinizing state laws, you also have the Commerce Clause cases. Remember the direct effect test? Where the court is carefully scrutinizing federal laws. Do you see the parallel? On the one hand, the court's saying that these laws are unreasonable. They apply a presumption of constitutionality. On the other hand, they said that these federal laws are not a regulation of commerce. This is not commerce between the several states. The same court that was skeptical of state laws was skeptical of federal laws. You see, this all comes together, right? And so the reaction to the conservative court was not just by the federal government, it was also by the states. And in 1936 to 37, things would change. What happened? In 1936, November, President Roosevelt had a landslide re-election. This ushered in the true New Deal. And Roosevelt set his sights on the court. And he began discussing what to deal with the court. Now, one of the ironies is that there were attempts to get some of the justices to retire. And one of the dumbest moves ever, they made it actually harder for the justice to collect the pension. McReynolds was actually ready to retire. He decided not to because he was going to get his pension. But Roosevelt did not have any picks during his first term. People don't remember that part. Oscar, they replaced all 9. You're right, they did eventually. It took him a while. His first term, he had no picks. So Roosevelt had an idea, a court packing plan. And the rule set like this. For every justice over the age of 70, the president will get a new pick. He can then replace, I think, 4 of the current justices in the court and the lower courts as well. He could redefine the court overnight. So when did Roosevelt announce this plan? He announced it in 1937. And around the same time that this opinion was, that this plan was announced, the court decided West Coast Hotel v. Parrish, where the court overruled Atkins. So the story was that I learned in law school. It's not true. But the story that I learned in law school is this, that the court changed its positions to fight off Roosevelt. They said, look, FDR, you don't need to pack the court. We're good. We're going to uphold your agenda. We're going to uphold these state laws. We're going to uphold these federal laws. We're going to do NLRB versus Jones and Laughlin Seal, direct effects test, gone. We're going to do substantial effects. In the same period that the court upheld the Washington law, the court upheld the NLRB, National Labor Relations Board. And the thinking was that Owen Roberts changed his vote. Why? In 1936, the court said that a New York minimum wage law for women was unconstitutional. But then in 1937, with West Coast Hotel, they upheld the Washington minimum wage law. Thinking, wait a minute, why did Justice Roberts say the New York law was unconstitutional in 36, but then Justice Roberts said the Washington law was valid in 37? The story went, Roberts got afraid of FDR, and to avoid a conflict, he changed his mind. This switch, this change was called the switch in time that saved 9. The switch in time that saved the 9 justices. It's based on the expression, a stitch in time saves 9, right? That if you basically sew your socks together, you don't have to replace them, right? It's kind of a weird expression. That's what it says. And people said this was actually kind of a good thing, right? That when a president applies pressure to the court, that maybe the court should surrender a bit and avoid a conflict. Some people said that Roberts was right to do it, if that's what he did. Now, we know with the benefit of hindsight that Roosevelt did not pack the courts. In fact, his own party, the Democratic Party, opposed the court packing regime. That this was a terrible idea to expand the court. Even if the court was ruling against them, it wouldn't be long before vacancies arose and you can replace the members, right? The Supreme Court's not forever. So Roosevelt did not expand the court, but he would have if he could. It's a lot easier to add seats to the court than to amend the Constitution. Far, far simpler. But we now know this didn't actually happen, right? We know this did not actually happen. How do we know this? We have records. So there's something called a docket book. Where is it? Somewhere here, right? There's something called a docket book, where the justices write down their votes of how cases are decided before they're published. And Justice Roberts announced his vote in West Coast Hotel before the court packing plan was announced. Again, Roberts announced his vote to the court before the Roosevelt agenda came out. So he was already changed his mind. So how do you reconcile these cases? It's actually not that hard. In Moorhead, this New York case, no one asked to overrule Atkins. And because no one asked to overrule it, he didn't do it. But in West Coast Hotel, they asked to overrule Atkins, and he did it. That's how you reconcile them. So Roberts didn't cave to the president. That would never happen. But people still sort of have this mythical account of West Coast Hotel. But no matter how you slice it, West Coast Hotel changed American constitutional law, where the court basically signaled, okay, the Lochner era is over. That whatever started in O'Gorman and Nebbia was now full. And they formally overruled Atkins. They didn't formally overrule Lochner. They didn't have to. But Lochner was basically dead at that moment. And now West Coast Hotel was the way the court will decide these cases. Everyone get that chronology. The chronology there is very important. I learned this since law school all wrong. I love my professor, but we didn't know better back then, even 15 years ago. Michael's at hand?
Yeah. So you're saying like Lochner's dead, but this is actually, I don't know what I'm asking. Let me think about it, please.
Okay.
It's a bad question.
I do have a question.
Sure, go ahead, ma'am.
So the Great Depression is happening or ending during this time?
Oh, it was not ending. It was
It was still like full flare.
full flare, yeah.
So in the previous case with the milk case, does the Great Depression, if it wasn't the Great Depression happening or something happening on a major scale like that, do you think the outcome would have been the same?
Let me ask you a question. I asked actually this question to the Oscar Fidel a few minutes ago. Did this law help consumers? The milk law?
Did it? No, it did not.
Yeah, it kind of hurt them, didn't it?
Right.
So is this helping people in the Depression?
No.
It's helping the milk distributors.
Right.
So I don't think this law actually helped anyone. I mean, to be completely candid, most of these laws weren't helping people. There's, again, this is Josh Rant, but there's some evidence that FDR's policies prolonged the Depression. They didn't end it. My beloved grandfather, who died many years ago, he was a New Dealer to his dying day. But I was like, Grandpa, these laws made the Depression worse. All these public works projects are just spending money, creating inflation. He's like, no, they were good for the people. So I'm not going to have the argument now. That's for another day. But the answer to your question, though, is should the court factor in the economics of the day when they're deciding these constitutional issues? I'll give you a variant.
But I want to say one of the dissents was like, we shouldn't do this because the economy changes. Like, we can't make decisions right now because the economy is constantly evolving.
Right. So let me give you an example, right? Paper money. Why did we adopt paper money? Due to the emergency of the Civil War. Right? If you remember, they upheld this saying, look, we're in the Civil War. We need this paper money. And then 15 years later, they said, well, Civil War is over. We're still going to have paper money. So it's usually the case that when you do something in a time of emergency, when the emergency is over, they kind of keep doing it. There was another case, I don't assign it, involved mortgage foreclosures, where I think it was Minnesota basically made it illegal to foreclose on a mortgage. So if you didn't pay your mortgage, you couldn't foreclose, which seems great to the people who didn't pay their mortgages, but people did. They're a bunch of suckers, right? And the banks were left out. What the court said there was, well, we're in the middle of a depression. This is an economic crisis. We can give the government this power. But generally, power once surrendered is never reclaimed. It's not, you can't really get it back. That's just the course of human events. Good question. Michael, did you figure out what you want to ask or no?
Yeah, I guess I was about to ask, like, you saying that West Coast Hotel overruled, I mean, like, just kind of like, I guess, rendered Lochner obsolete or something to that effect.
Correct.
And I was confused because I thought that since we're in the New Deal, now we're starting to make like distinctions between economic and personal liberty, but I was like I was thinking the wrong way. You're talking about like a kind of the presumption of liberty stuff is
Let's cover West Coast Hotel. I think maybe it might answer your question. We'll come back if I don't. No, we didn't do it yet.
Okay.
Brian, let's do it. Stephen, you want to give a question first?
Yes, well, like, when it comes to Lochner, couldn't we just say that O'Gorman made it like new?
Yeah.
Instead of,
Yes. Yeah. No. To be sure, O'Gorman, I think as a legal matter did, but that wasn't a very high profile case. West Coast Hotel was like a national, being on the front page of the newspapers, right? This is the one that really signaled, okay, adios Lochner era, bon voyage, we're done, right? It's the Titanic at the bottom of the sea. Oscar?
I can't find the chart thing, but for the enumerated powers part, NLRB is where they started giving them, that was the substantial excess, right? So that's where they started giving them like a lot more power.
Yeah, do I have it here? I can't remember if I have this one. Where is it? I don't think it's here, actually. I'll find it in a minute. All right. Brian, you want to give me the facts in West Coast Hotel, and I'll bring up the chart that.
So Parrish was a chambermaid at the West Coast.
What's a chambermaid? She cleans. Yeah, she's a maid. Okay. So, do you know what the chambermaid is? Okay.
And Washington had implemented a minimum wage for women. And the owner of the hotel refused to pay the minimum wage, saying it was a violation of his liberty to contract without due process.
Correct. Okay. And I found that graphic, by the way. So if you look here, I know this is hard for you to see, but trust me. This is NRB versus Jones Laughlin Seal 37. Then Darby's 41, and then Wickert's 42. Right? So what happened in 37? Also, West Coast Hotel v. Parrish. Right? What year was Carolene Products? 1938. So between 37 and 38, they're deciding Darby. I'm sorry, Jones Laughlin Seal, then West Coast Hotel, and then Carolene Products, all in the same period. These are cases where they say, okay, government, you're going to win. All in the same period, all through a couple of years.
You can see it in the progressive era where, I guess, so like. Well,
Right. Hold on. Let me make this bigger so you can all see it. Hold on. It's actually a fair point that Oscar raised. I want to make sure I do this one fairly. Page 24. All right. So let's just sort of juxtapose this around the same time. Okay. There it is. We can see it a little bit bigger. Right. So progressive era, right? 1895, 1903, right? EC9 lottery ticket cases, right? Lochner's 1905. So in the same time they're deciding the Lochner cases, they're also deciding the direct effect test. The government must have a close relationship with interstate commerce to enact their federal laws. Right? Hammer. Right. That's around the time of Meyer and Pierce and Buchanan. Again, the court's going to be skeptical of these laws. But then we get to 1935. Schechter Poultry. This is sort of the last gasp where the court says we're going to try to police the bounds of federal power. But when you get to 37, you have both West Coast Hotel and Jones and Laughlin Seal, where the court says, okay, we'll use substantial effects test for the Commerce Clause, and we will use the presumption of constitutionality for due process. They both collapse in the same year. This is 37, the most important year of constitutional law in the 20th century. Everything collapses in that 1 year. Once you get past 37, it all goes down, right? Darby, Wickard, part of Atlanta, and so on. Same way, Carolene Products, Optical, everything goes downhill. Yeah.
So it would be fair to call presumption of liberty and the presumption of constitutionality, like philosophies that the court follow at the time? Like,
I don't know what philosophy is. They're presumptions. They're the ways. They're ways of approaching cases, right? They're methods of judging.
But they apply broadly to all
Yes.
types.
Yeah. All right, Brian, try again. So Elsie Parrish was a chambermaid. By the way, Parrish couldn't bring this lawsuit herself. Her husband actually brought it for her. All these quirks. She back at the time, women couldn't litigate in their own name, so actually it was her husband bringing the challenge. And what did they argue, Brian?
Parrish?
Yeah, what did Elsie Parrish argue?
They asked to overrule Adkins specifically.
Right. So I have a picture of her somewhere. Okay, so that's Elsie Parrish. You see, I think she's making a bed, and that is the present location of the West Coast Hotel in Wenatchee, Washington. I kind of want to visit there, but I've never gotten around to it. Okay. So we'll discuss later this semester something called stare decisis. Stare decisis is this principle. It's Latin for stand by the decisions. Stare, stand, decisis, decision, right? Where the court often stand by their decisions. And there's very often aggressive debates about whether precedents should be overruled or maintained. We'll see it most prominently in the abortion context, but whether they should maintain Roe against Wade. But here, the court overrules a precedent, okay? And they overrule Atkins, which was not even 13 or 14 years old at this point, okay? Why is Atkins overruled? You.
Okay. Well, one, it's ruling a minimum wage law constitutional, and Atkins did the exact opposite.
Right. So why does the court now judge the women with the women's minimum the minimum wage law for women to be unconstitutional?
I believe one of the reasons they gave were changing social circumstances such as the Great Depression and women's liberation.
But wouldn't women's liberation cut the other way? Wasn't the point of Atkins that women now have the right to vote and they're equal? They can negotiate their own wages. Which way does women's lib cut?
The opposite way this time, or in favor of the state's interest.
Oh, so it's that women, because they're equal, deserve this higher wage. Is that the argument?
I suppose.
Okay. So there's a tension here. I just want to just focus on this one. If you remember, Justice Sutherland wrote the majority opinion in Atkins, and he said, this is a law about minimum wage for women. Women are equals. They can vote. They have political equality. If they want to negotiate their own wages, they can. But here, the court uses that almost the other way, saying, look, because women are in the workplace, they should be entitled to the same wages as everyone else. At the time, there weren't really minimum wages for all professions. And I don't think maids had minimum wages in general. So this was a new innovation. And if I had to, maybe more can say this, I think probably most maids were women. I'm not sure there's a profession that actually had guys working it. Maybe it was, I'm not sure. So this was really a profession for women, the only women could be in, and that the wage would apply for the women. In this case, the West Coast Hotel didn't want to pay her this wage, and that was the basis for the litigation. All right. I'll just walk through the opinion by Chief Justice Hughes. He basically says there's not really a liberty of contract in the Constitution. There's not this absolute liberty. Okay. Liberty is subject to restraints, but there's going to be deference for them. And here the court cites what precedent? Mueller against Oregon. Right. The court says we must preserve the strength and vigor of women. Why? So they can reproduce. So the same sort of stuff that was in Mueller against Oregon about the maximum hours is brought back in West Coast Hotel. The court then says, what about Atkins? Well, how do you reconcile Atkins with Nebbia and O'Gorman? You can't. And because you can't reconcile Nebbia with O'Gorman and Nebbia, Atkins must be overruled. This law is not arbitrary. And that's it. It's a very short opinion, but it accomplishes a massive change in the law about how these laws are going to be reviewed. Yes, Taylor.
You said that the liberty of contract is not absolute because it's subject to restraints, but that there's deference to which one.
There's deference to the government to restrain the liberty of contract. So any more questions in the majority? It's actually pretty straightforward. Justice Sutherland dissents here. If you recall, again, he wrote the majority opinion in Atkins. Sutherland seems upset. And he basically says to Justice Roberts, we have to decide the Constitution based on what we think is right, not based on what the government thinks. In other words, the presumption of constitutionality gives the government a say in what's valid rather than the judges, or who decides. They're saying that the government gets to decide whether a law is valid. He says that we judges cannot subordinate our convictions to the other branches, that we have an independent obligation to decide these things. Chelsea made this point a few minutes ago. He says, economic conditions have intervened, right? But that shouldn't change the meaning of the Constitution. The meaning of the Constitution is fixed. Its original meaning doesn't change. Whatever it meant in 1868, that's what it means today. And we shouldn't base it on these sort of social times, because times come and go, but the rulings will remain forever. Long after the Depression's gone, Westminster Hotel is still good law. It's often the case the court decides things based on things going on in the world, and they usually regret it once they do. Right? Because we never remember, like, what was the big issue when I was in law school? Guantanamo Bay, Afghanistan. We even talk, it doesn't even matter anymore. But those precedents were still set in that time. And when you make the law based on sort of the controversy of the day, you're stuck with a precedent long after the controversy's gone. And I'm still stuck teaching it years later. I am. Okay. All right. Questions on West Coast Hotel. Very important case, right? This case solidifies the presumption of constitutionality. But still, in theory at least, it's possible. It's possible that the plaintiff can prevail, right? The hotel maybe could have won if they showed the law was completely unreasonable. I mean, imagine Washington imposes, just say the minimum wage was $1 an hour, make up a number, right? Let's say they made the minimum wage was $20 an hour, right, for a maid. Just say, I don't know, the legislature goes wild, right? $20 an hour for a maid back then when the wage was always $1. I like to the court say, well, maybe that's too much, right? That might put every hotel out of business. They can't afford that. So there's still probably some bound of rationality under this approach where the court can actually decide if the law is reasonable. But whatever the wage was in this case, that was enough. Overruled Atkins. All right, questions on West Coast Hotel? No? Oh, I forgot, Addie, we have our event today. Do you want to announce it? I forgot.
Yes.
I'm sorry.
We have
Good
an
segue.
event today, and we have one Wednesday, and we have one next Monday. And then FedSoc doesn't have anything else. Today in Garrett Towns, 1 to 2, we have Chick-fil-A and a panel on whether fetuses are protected under the Constitution. So might be a nice preview before y'all get into any of the abortion cases.
Very good. All right, thank you for reminding me. Yes. Okay. Any questions before we move on to Carolene products? All right. So moving right along. Oh, yes, sir, Bobby.
So do you think that they don't consider the equal protection here just because no one mentioned it? Or do you think they would not have noticed that?
What was still the law of the land in the 1930s in equal protection? What precedent?
I forget the name, but I think it was mainly premised on race versus gender.
Did the equal protection clause even affect sex?
I don't think so.
What about Myra Bradwell? Mueller against Oregon. The Supreme Court wouldn't actually say the equal protection concerned sex discrimination until the 1970s. So there were all these cases where men were treated different than women, and that was not an issue of equal protection. Okay. Plus is the name of the case, by the way. Right? Separate equal. All right, let's do Carolene products. Now, Carolene products was not a particularly important case, except for the famous footnote 4, which we'll talk about. Now, if you'll notice, this is United States versus Carolene products. It's a federal case. Wait a minute, Josh, didn't we study federal cases the first half of the semester? Yeah, we did. So this case involves the Federal Filled Milk Act. Chelsea, why don't you just give us the facts, please, in this case?
So in this case, Congress passed the FMA, which is
Filled Milk Act, FMA, for the cool kids.
which criminalized the shipment of interstate commerce of skim milk compounded with oil and fat or other things that resemble milk or cream.
Okay, so what's going on there? What is, do you ever have filled milk? Condensed milk?
I have no idea what that is.
Anyone know what condensed milk is?
Oh, condensed milk. Okay, yes.
Tell me, please.
So it's a creamier, like, I think it's a thicker, creamier that we use for baking.
Do you know why it's in a can? It's not refrigerated.
Because, yeah, it's not fresh.
Correct.
What is it called? Perishable.
Right, so it's non-perishable. So this is actually kind of mill knot. Oh gosh, I know all about this stuff. That is my favorite case of the semester. I love the facts in this case. So what is filled milk? So in this one, what is filled milk? Filled milk is where you take the dairy, the fat, out of milk and you replace it with a vegetable oil, right? And as a consequence, it won't spoil. You can keep it in a can at room temperature. This was a major innovation in technology. Why? Because back in the 1930s, not everyone had refrigeration, right? Right? Not everyone had refrigeration. This was a way to get nutrients and milk to people in communities that did not have refrigeration. So who hated this product? The dairy farmers. Oh, they hated it. Do you know what else the dairy farmers hated? Margarine, right? Why? Because margarine is stable at room temperature. You don't need refrigeration. So there were these massive efforts by the dairy farmers, sensing a pattern, to shut down margarine and to shut down filled milk. So one of my favorite cases, there was actually a law that said that margarine could not be yellow. You had to dye margarine to be pink. Exactly, so people would want to eat it, right? And what about filled milk? All these people went to the state government saying, "Oh, this is not healthy. This is not healthy for you. Let's ban it." And they got a federal law to ban the sale of filled milk across state lines. Again, this is all nonsense junk science. In hindsight, the filled milk is actually healthier. It's less cholesterol, right?
This kind of goes to what you were saying, how, the Great Depression is going on right now. And this might be beneficial to people who can't refrigerate. You don't have to buy so much milk and so on. However, the ruling is not beneficial to people as what's happening during this time.
Yes, ma'am. Right. I mean, this was not actually a law that benefited actual human beings who drank milk. This was a law to benefit dairy farmers. And to be sure, people worked in dairy farms. I don't want to trivialize that, but this was not really a law in the public interest. So Charles Hauser was the founder of the Carolene Products Company in Litchfield, Illinois. And he had a product which they called Mill Nut. Now, I have a picture of it somewhere here. Where is it? Originally it was Mill Nut, N-U-T, as in like coconut, use coconut oil, and they changed to Mill Knot. That's like not milk. Mill Knot, not milk. See it? And I actually have a can, which is you still buy it today, and I have all these cookbooks from the 1930s. I got a collection of all these things. I love this stuff. I have another one over here. If you want to come after class, I'll show it to you. Not passing around. Nope. Keep these where I can see them. I love you all, but not that much. No, I'm kidding. Charles Hauser was a remarkable person, and he made it his life to sell this product. So what's U.S. versus Carolene product? This was a federal prosecution against the company for selling the milk in violation of the law. He knew it was illegal. He was selling it anyway. He was selling milk in interstate commerce, shipping it across state lines. It was actually prosecuted by the government. So there's a great story, which I found out later. Randomly, I was blogging about this case, and I got this email out of the blue from his granddaughter, Charles Hauser's granddaughter. And I talked to her on the phone for a long time. Want to hear a crazy story? After Hauser was convicted, he got a pardon from FDR. FDR pardoned this guy. And Hauser was he hated FDR so much, he hung out, I think, in the bathroom of his social club, the pardon. There's another great story they told me, which is probably not true, but it's a good story anyway, where apparently Hauser asked his lawyer, how do I get a test case? He said, okay, I have an idea. Drive your milk truck, I think it's from West Virginia to Ohio, drive it across state lines to get arrested. And he did. And his lawyer said, don't worry, they won't actually hold you in jail. And the judge refused to let him go. So the marshal actually held him at his private home for the evening, just because he put him in jail. The last story I like is decades after this was happening, he built a factory on the state line. I think it's in your book. There's a picture of it, right? Yeah. And he basically made it so that the filled milk would never cross state line. There was actually a brass rail down the middle of the factory on the state line so that you would never have it crossing state lines. And it's a regret of mine. I really want to visit it, and I just could never make it work, and it closed down about 10 years ago, so I regret that deeply. I talked to one of the people who worked there. I was like, yep, we never crossed that line. We're allowed to cross it. They had a truck base on both sides to avoid it. The last part I'll mention is decades later, in the 1970s, there was actually a challenge to the Filled Milk Act, and a federal court in Illinois declared it unconstitutional. So Hauser's life work prevailed eventually. Okay. So the actual issue in Carolene products was straightforward, right? He was literally shipping this product across state lines. And the court also rejected a challenge based on the due process clause of the Fifth Amendment, again, because we have a presumption of constitutionality. But then Justice Stone wrote this opinion, and he included this very famous footnote. I always tell my students, don't bury important stuff in footnotes. It's a bad idea. But the court actually had this footnote, if you read the report, that spanned across 4 columns. It was a very long footnote. And what the court does here is they sort of refine the presumption of constitutionality. They qualify it. And they do a couple things. All right? The court says, generally, we will apply the presumption of constitutionality. But we will not apply it in these 3 cases. Now, before I give them to you, I'll make things very clear. This is not actually holding, right? At most, Carolene products had 4 votes. You need 5 to have a holding. Justice Scalia called them the dictamizers. God, I love him. Right, the dictamizers. It's basically a dicta. But it would prove to be very influential on the court. What the court was saying is, look, we are not going back on Lochner. Lochner's dead, dead, dead. But we still realize there might be cases where the court might have more aggressive judicial review. So in these cases, we are not going to apply a presumption of constitutionality. We'll apply a presumption of liberty. So what Carolene products did was sort of cut in half rights. That if you're in this bucket of economic rights, you're with West Coast Hotel, right? You got a presumption of constitutionality. But if you are in the category of personal liberty, we'll give you a presumption of liberty. That's why, right? That's why these cases are all scattered. Meyer and Pierce were deemed individual cases, individual liberty, personal liberty. That's why they've been salvaged as First Amendment cases. Okay. Everyone with me? So we said last week that in the 1920s, Barron v. Baltimore was still good law, right? The idea was the Bill of Rights still had not yet been incorporated. But by the time we get to the late 30s, the court started to extend the provisions of the Bill of Rights to the states. Now the states were limited by the First Amendment. So the first exception where the presumption does not apply is where law violates a specific prohibition of the Constitution, specifically the first 10 amendments. So if a law runs afoul of the Bill of Rights, do you apply a presumption of constitutionality? No, you do not. You apply a presumption of liberty. If there's a violation of free speech or the free exercise of religion, the burden is still on the government. The government has a burden to defend their law. We apply what we would call later strict scrutiny, right? When there's generally a violation of free speech, for the most part, you apply strict scrutiny. Not always, but close enough for here. Okay? When you have a law that violates the first 10 amendments, you can apply something like strict scrutiny. Everyone with me? Okay. That's exception number 1. Exception number 2 is a little bit trickier. Exception number 2 is based on what we might call political process theory. So how does this work? The basic thrust of Justice Holmes is that if there's a really bad law, it will be repealed, right? If there's some law that's really unjust and unwise, then we should just repeal it. It should be for the courts to get rid of these laws. So if New York wants to regulate how many hours bakers can work, and if Oregon wants to regulate, what the wages are of maids, they can do that. If these are such terrible laws, it'll be repealed. But the theory is not all bad laws can be repealed. Why? Because not everyone has the same access to the political process. So laws that restrict the political process are not reviewed with a presumption of constitutionality. Laws that limit the political process might be reviewed with a presumption of liberty, where the government has the burden. And they give a couple examples of laws that might limit the political process. For example, restrictions in the right to vote. If you can't vote, you can't repeal laws. Restriction on disseminating or sharing information. If you can't share opinions with your colleagues and friends about why something's bad, it's hard to repeal those laws. Interference with political organizations, right? If you can't have political parties that gather, it's harder to gain momentum to repeal bad stuff. And limiting peaceable assembly. Now, for the most part, these all are in the First Amendment and maybe the 15th Amendment right to vote, or the suffrage amendment as well for the right of women to vote. But it's not just that they're in the Constitution, that these rights are more important because they are sort of the way you get rid of laws that are undesirable. Now, you're saying, wait a minute, Josh, this was decided during the height of Jim Crow. I mean, my goodness, people were denied access to the ballot box on a daily basis. How could they say this? This is one of the things they kind of said and didn't really mean. And that maybe they'll get around to it later. But they kind of just put this in a footnote, saying, we're just saying that maybe it's appropriate when this is happening. We're not really saying what's going on. This is why Scalia calls it a dictum, right? The case is about filled milk. And they're talking about the right to vote, right? This is like how you should not judge, right? That if there's a case about one thing, you shouldn't, decide all these ancillary other issues. And by the way, never follow up on them either. There were lots of cases at this time where the right to vote was violated flagrantly, and nothing was done about it. Everyone with me? But again, I've said this many times in this class, when you write something down, it has a way of coming true later. Maybe long after you're dead. Okay, then there's the third one. That is relevant. And this again, they didn't really mean when they said it, but they wrote it. They said that more exacting scrutiny may be appropriate when the courts review statutes directed at particular religious or national or racial minorities. And what cases did they cite to discuss this one? Meyer and Pierce. To be sure, right, Pierce was about Catholics, okay? And Meyer was about a German teacher, but that wasn't what these cases were about. These cases are about the right of parents to raise their children. They basically, the phrase retcon, can you know the phrase retcon like in a comic book? They changed what Meyer and Pierce were about to make it fit into this new doctrine. Like, okay, well, these were kind of Lochner cases, but we're going to reimagine them for them to be about minorities. It's just simply not true. And moreover, there were lots of acts against religious and national minorities at this time that were not reviewed with more scrutiny. Yes, Michael?
Were we saying that Pierce, that it was like a pretext for discriminating against Catholic people anyways?
Oh, that was certainly there. That's certainly there. There's also a military academy as well, if you remember.
Yeah, you're
right? They took parts of the cases that fit into the agenda and they sort of just ignored the other parts.
So like if it was racially or religiously motivated, then it's like, okay, we need to do this exact judicial scrutiny. And like you said, they just plug those to make it.
So let me go back to Korematsu for a minute, right? So this again was before Korematsu. Korematsu came in, was it 43 or 44? So this is shortly before Korematsu. The court actually said in Korematsu that when there's a racial classification, we apply exacting scrutiny. So believe it or not, Korematsu actually invoked this principle, but then they upheld the racial, the Japanese exclusion order. So not so exacting. So I'm trying to tell you, this opinion had a wave on a lot of other cases at the time. When you get to the Brown decision, the 50s, right, desegregation, this sort of comes back into play. So it wouldn't be almost 17, 18 years till they actually start doing stuff.
So Korematsu is living out this principle, kind of.
Kind of, yeah. Yeah, in fact, if you read Korematsu, I think they say, you can check them, I think they actually say that racial classifications demand exact scrutiny. They use almost the exact same language. One thing I love about this class is when the pieces all fit together, you see it, right? So the first edition of Randy's book, he put the thing straight chronology. Everything was chronological. And there's value to that, but confused the hell out of students. So now I have to kind of keep, okay, this is like the third time we're doing the 1940s, right? We keep going back to this period. We did it once with the with Commerce Clause. We did it with executive power, Korematsu, and now again with the due process stuff. And now it's like a cake. Everything kind of builds up on top of each other. So what's the upshot of Carolene products? It basically slices common law in half. If there's some right that's enumerated, it gets exacting scrutiny, right? Free speech and so on. But if there's a right that's not enumerated, contract, it gets deferential review, presumption of constitutionality, right? Carolene products basically cut constitutional law in half and said, if you fall in this bucket of stuff, good for you, you get a presumption of liberty. And if you fall in that bucket, too bad, you get a presumption of constitutionality. Right? It's sort of bifurcated, cut in half all of modern constitutional law. It left open, if you're in the Bill of Rights, political process theory, some sort of targeting of racial, or if we call it discrete and insular minorities. But everyone else, you're on your own. The court even leveled up, they said a bit more. There's even more searching inquiry when there are statutes directed to discrete and insular minorities. What does that mean, discrete and insular minorities? Insular means separated, people who themselves can't change the political process. So it's reinforcing that there's some people who can't themselves change the political process. The courts will reinforce representation. Who could they possibly be talking about? You're talking about Jim Crow, right? They took a case about filled milk to lay out a theory that led to desegregation of schools, right? This is why this footnote had so much significance, even though itself wasn't even law. Right? They're saying, here's some stuff we're going to do later. We're not doing it now. We're talking about filled milk and condensed milk. But we're gonna put this stuff out there, and maybe after we're dead, something will happen with it. And that's indeed what happened. So footnote 4, again, West Coast Hotel solidified this presumption of constitutionality. Right? Where's my chart? Right, West Coast Hotel solidified the presumption of constitutionality. But Carolene Products qualified it. In other words, West Coast Hotel said, we're not going to review anything with scrutiny, right? Everything will be deferential. And then Carolene Products said, well, not so fast. Not so fast. Most things will get the presumption of constitutionality, but here are these 3 categories we use presumption of liberty, right? It's sort of separated. So this is why it's a different column. That footnote 4 of Carolene Products sort of qualified the presumption, saying, well, we provide liberty here, constitutionality there. Everyone see how that happened within a year, right? They did West Coast Hotel, like, wait a minute, maybe we went too far, guys, right? We don't actually mean what we said, right? It can't be that the government always wins. Let's have some cases where the court can still review legislation that might be unreasonable. You have the Bill of Rights, you have political process theory, you have the racial minorities, we'll have these other carve-outs, but otherwise the government will win. Everyone see that chronology happening back to back. There's a lot of change being made in a very short time.
But wouldn't West Coast Hotel still fall within the structure that they have in footnote 4?
Yes, it does. Because it's not enumerated.
Yeah.
Right, the right of contract is not written down anywhere. And because it's unenumerated, you get the presumption of constitutionality.
Right.
Yes. Everyone see that? The right of contract, the liberty of contract, is not enumerated, so it's afforded only presumption of constitutionality. Whereas free speech, free religion, and so on is given a presumption of liberty. How are we doing here?
Quick question.
Yes, ma'am.
That insulated, the term has said insulated, something. Would that be vet too, like the people that's in a mental institute?
So discrete and insular minorities, would you say that a person locked in an institution is that category? I sure as heck would. Yeah, I mean, Buck v. Bell's kind of an outlier. It's not really, but it sort of is. The court didn't do much judicial review there at all. In fact, there was another case decided. What the hell is the name of the case? Blanking on the name. It involved people who were in prison. It involves sterilizing people in prison. I'm blanking the name. But there's the case actually found that this law is unconstitutional. What was the name of that case? It's from Oklahoma. Yeah, Skinner. You beat me by half a second. Skinner. Yeah, Skinner, ex rel v. Oklahoma, 1942, which came after Carolene Products. And this held that the state couldn't sterilize people as a punishment for a crime. Although it was kind of a weird case because there were some wrinkles in there. Yeah, Oklahoma ex rel v. Skinner. Or Skinner v. Oklahoma ex rel. Sorry. Yes, Taylor.
Since a couple of the cases said like women were inferior and had more water in their blood, would you consider women also insular?
You're raising such a good question. At the time, yeah, I would. But the wrinkle is, again, the court didn't really mean what they said at the time, right? They didn't say, okay, so let's go overrule, Myra Bradwell v. Illinois, right? Let's go over all these other cases. They didn't quite do any of these things yet. In fact, there are all these laws regulating women about, could women work in bars and so on. There were countless laws excluding women from various professions. That's what I'm trying to tell you. They use these words, and I don't think they really meant it. Or it's more like, let's just say this stuff now and see what happens later down the road after we're dead. Right? Carolene Products, people's like, oh, great. I love footnote 4. This is awesome, right? It didn't change that much, at least right away. But it will become a very important theory decades later. Bobby?
So suppose after this case, a new president was elected and he said, this is clearly unconstitutional. I'm not going to enforce the milk. like if you sell milk across state borders, I'm not gonna enforce it. Do you think he could be removed for not faithfully executing that?
All right, so this is a question. It'll take me a minute, but I'll explain it. So the president takes an oath to the Constitution. It's actually a separate oath only the president takes. And the president has a duty to take care that the laws are faithfully executed. So let's say there's a brand new statute that the court's never passed upon. And the president says, I didn't sign into law. My predecessor signed into law. I'm not going to enforce it. What's the remedy there? Can a court order the president to enforce the law? I think the answer is no. I don't think a court can do that. What about impeachment? Can the president be impeached for not enforcing a law? Well, that actually happened. President Andrew Johnson was impeached because he basically ignored Reconstruction. And one of the charges was he failed to enforce Reconstruction laws. He was not removed. He came one vote short, but there's at least some precedent saying he could be impeached. The harder example, though, is let's say the Supreme Court upholds a law and the president is not going to enforce it anyway. Has that ever happened? Yeah. Happened this year. TikTok. Right? There was a constitutional challenge to the TikTok ban. A couple of days for the inauguration, the Supreme Court upheld it. It said that this law is valid. It doesn't violate the First Amendment. President Biden said, I'm not going to enforce it. The law went into effect on January 19th. My goodness, the timing was just remarkable. The day before the inauguration. Biden said, I'm not going to enforce it. Trump says, I'm not going to enforce it either. In fact, Trump just renewed another 75-day extension. So you can have all of your cat memes, right? So yeah, we have a situation where the Supreme Court upheld the statute is valid, and now two presidents have said we will not enforce it. There's been no attempt to impeach either of them. And in fact, the president's told his attorney general, you cannot bring any prosecutions against those who might violate it. So TikTok and Verizon and T-Mobile and all these other companies who host TikTok on their servers are not going to be subject to liability. It's a very, how do I put this, dicey issue when the executive decides to not enforce the law. Now, I think it's actually quite permissible, in fact, desirable. The president has a duty to determine what the laws are and to faithfully execute them. But you're sort of in uncharted waters about what happens when that goes on. Lincoln for sure thought he could enforce the laws. He had a very strong vision of that. The harder one is when the court tells him you must do it. So for example, a court says you must turn those airplanes around. You must return this alien from El Salvador, or wherever it is. We have independent, co-equal branches of government. Why is one predominant over the other? People don't like when I say it, but it's sort of true, and maybe we'll see very soon what happens. Okay, what else? I forgot where it was. Okay, anyway, so Carolene products we call stage 3 qualified the presumption of constitutionality, but critically, they still weighed the evidence. They still said, well, we have all this evidence showing that milk is unhealthy, that distilled milk is unhealthy, and that's good enough for us. But the big case that changed everything was Williamson against Optical from 1955. The same time the courts was deciding Brown and saying that schools have to be segregated, they decided Optical. And Optical is by Justice Douglas. So what am I up to? Next? Yeah. Can you read the facts, please, in Optical? I mean, the facts are the same, both of them, but yeah, so the conflict's the same. Right, we gave you the lower court opinion and the Supreme Court opinion.
So the article is a politician, and he's the plaintiff in the original case, and they are challenging an Oklahoma law regulating individual care that restricted from prohibiting and taxes duplication without prescription, advertisement of the sale of optical goods, and then basic office.
Very good. All right. So thank you for that. So glasses, right? I think a lot of you have glasses, right? I've had glasses for years. I didn't used to. If you look at my old videos, I only got them. I was thinking my second, third year here. There are two types of doctors. There's opticians and there's ophthalmologists. right? Opticians are based people who can kind of fit lenses and make the glasses. Ophthalmologists are actually medical doctors that can diagnose diseases and see if there's anything wrong with your eyes. Okay. For the most part, when you go to imagine a lens crafter, right? Let's say you need a copy of your glasses made, right? So what they do is they take your glasses, they put in this little device called lensometer, and they can figure out the magnification, the spheres, everything else. They can basically make a copy of it. There's no actual need to inspect your eyes. They don't have to list if you're healthy or not. They just make a copy. In the 1950s, a company opened called Lee Optical. Picture of it somewhere here. And their sort of selling point was, we will make your glasses here, and you don't need to go to an eye doctor, right? So if you want another copy of your glasses, we'll make it kind of like a lens crafter. Unsurprisingly, the eye doctors of Oklahoma didn't like this law. Why? It creates competition. So sensing a pattern, how do you get rid of competition? You ban your competition. It's very effective. My goodness. Why compete on price when you just criminalize the other side? It's just much easier. So the people in Oklahoma, the eye doctors, lobbied for this law that banned making glasses without having an ophthalmologist present, right? You needed basically a prescription and a doctor to make these lenses. Now, the government said we need this law because it will promote health, right? Because if people go to an eye doctor more, they're more likely to get some sort of a cataract or something detected. It'll make people healthier. Did this help consumers? No way. No. Consumers like the cheap and the ease of going to one of these Lee Optical corner stores. So this goes to the court. It was actually a 3-judge panel in Oklahoma. The way constitutional challenges used to work is when you brought a legal challenge, it would go to a panel of 2 district court judges and 1 court of appeals judge, and then they have a mandatory review to the Supreme Court. So Brenda, help me out here. What did in the first case, Lee Optical versus Oklahoma, I'm sorry, Lee Optical versus Williamson, the Oklahoma case, what did the court hold here?
Essentially that it did violate his due process.
Why?
Because he had the right to make these glasses.
Was there a fit between the means and the ends here, Brenda?
I think they said no.
Okay, why not? Why was this law considered arbitrary?
Wasn't it just because they were still able to make the glasses, and that people just needed the glasses?
Is there actually any health justification for why you need a medical, William? Is there actually any health justification for why you need a medical doctor to just make copies of lenses and fit them into the frame?
There was no health requirement for
None.
An ophthalmologist or an optician to just simply place the lenses in the frames.
Yeah.
So that it was not rationally related.
Yeah, exactly. There's no actual relationship between having an eye doctor prescribe your prescription and putting pieces of glass inside frames, right? This is a artisan task. It's not very complicated. And people can do this. In fact, if you go to most eye doctors, the person doing this is not a doctor. It's just a clerk, right? Who's actually making the lenses. You know this. You're going to get your eyeglasses made. The person making it doesn't have a medical license. That they see for 30 seconds and move you along. That's usually how it works. They say the operation of the lensometer does not rise to the need of having professional supervision. They've used these machines for decades. And it basically is protectionism. They say this gives the eye doctors the power to keep out their competition. And they say this law is not constitutional. So why is this significant? Why did we bother with a lower court opinion? Because they're applying Carolene products. They're applying West Coast Hotel. They look, fine. There's a presumption of constitutionality. But Lee Optical's come forward. They've had evidence showing that this is not rational, that there's no reason to have this law. Right? This law doesn't make any sense. It's probably a pretext. It's about competition stifling. As a result, this is an arbitrary law, and it's not adapted to the end that's permissible. Okay. Everyone get the district court opinion. So, Michael, I think you're next. This goes to the appeal to the U.S. Supreme Court, and then Justice Douglas has a majority opinion. We'll learn a lot about Justice Douglas. What does the majority opinion hold, Michael?
that it's fine. It's constitutional.
Why?
I mean, it seemed like he was just kind of his like the gist of it was that they're not in the business of like evaluating the like merits of laws, rather like just kind of how like they were just really just deferring to the like state legislature.
Correct. All right. So what happens here is the court modifies the standard. Under Carolene products, the court applies what's often called a rational basis standard. Right? Does the government offer some rational basis, some possible reason why this law is reasonable? As long as the government has some, rationality of why they're doing this, that's enough. But Optical goes a little bit further. They don't apply a rational basis test. They apply what might be called a conceivable basis test. Is there some reason why this law might be valid? Even if it's not the real reason. Even if it's not the reason the government had. If there's some reason that we can make up, and they do make it up, that's enough. So imagine litigating a case against Optical. Whatever arguments are in the record, that's not enough. You also have to rebut arguments the court can make up later. That you might be there at a court and the judge says, well, the government gave reasons A, B, and C, but I want to look at D, E, and F. I just made up some reasons. How do you rebut those? It's extremely hard, Stephen. It's extremely hard to actually litigate in this fashion. But that's what the court basically says. If there's some conceivable basis on which this law can be upheld, that's enough. You're basically boxing against every possible opponent that you don't even know exists.
It's like, I thought that you don't know. Like, I did this when I like the Holmes dissent. It's like they don't look at any like counter argument. It's just like you just look as if they can make an argument that's like reasonable, or like any made up argument that's reasonable. If that's the case, then that's the end of it, right?
Correct. Right. So what they're saying here, I see what you're saying. So Holmes would say, I don't even care what the arguments are. So at least there's some candor there. Here the court's saying, well, we care about the arguments, we'll make up some for you. Right? We will ask, is there some basis? So let me just give you a couple examples, right? The court says it might be easy for an optometrist with space to be a front, right? Geography may be an important consideration. It may be deemed important to have these regulations, right? It may. Maybe someone who has a cataract and then wants to get a new pair of glasses made. If they went to a doctor, the cataract could be identified, and that's great, right? The court will basically make up rationales for why this law is valid. Under the Optical test, there's no way to win, almost no way to win, as applied, right? Even if the eye doctors, the opticians can knock out all these rationales, the court can supply additional ones. So one of my favorite examples, one second, Oscar, is actually a Louisiana law. You may not know this. In Louisiana, if you want to be a florist, you have to be licensed by the state. So literally, to arrange flowers, you have to have a certification from the state, which takes money and licensing. You have to go to school and training. And by the way, who determines whether you get a license? Other florists. Just like the bar, right? How do you become a lawyer? Other lawyers let you into the guild, right? So if you want to be a florist in Louisiana, they have to be admitted by other florists. So I swear to you, this is a real reason. Why does Louisiana require licenses for florists? What was the rationale? The court said, we have one. We're afraid that if people who are not adequately trained cut themselves while handling flowers with thorns, that there'll be blood that goes into the flowers, and that may become unhealthy. So we need to have a licensing regime for florists to keep blood out, which is just insane, right? It's protectionism in any way. But under the Optical standard, it doesn't matter. If the courts can make up a rationale, and this often happens at the oral argument. Can you imagine going to court and preparing, and you read the record, the record cold, and the judge says, well, I thought something else. What about this? Is that a good enough rationale? Yeah, okay, then the law is valid. So it's almost a way of unwinnable. If there's a conceivable basis, the plaintiffs cannot challenge it and they cannot prevail. Oscar?
So it almost feels as if they've like gone all the way to like what Justice Holmes had to do.
It doesn't feel it is that way. That's exactly right. That was the point Stephen made a moment ago. This is Holmes coming to fruition, right? What the lead Optical does is it gets rid of Harlan. It says we're going to just say for economic rights, we're going to provide a presumption of constitutionality that cannot be rebutted. Over here, that's hard for you to see, but it's an irrebuttable presumption.
And then there's also like a contradiction here because it's like, okay, if it can't be rebutted, why would they have to start making it with their own reason?
This is Stephen's point as well, right? Why don't they just say it's an economic right, you lose, right? Why don't they just say, you know what, you're asserting an economic regulation that's constitutional, motion to dismiss granted. Don't file a brief, right? Why waste time on the brief? Why have an argument? Why not just rule in favor of the government? I've often thought, Stephen, and your point, that would actually be more honest to stop wasting our time and making us litigate against something you can't win. Now, in fairness, there are groups that litigate these issues, and they win on rare occasion. So there's one case involving, this is one of my favorite ones, selling caskets, right, which are basically boxes that people are buried in, right? You can buy a casket like a Costco, you buy these things everywhere, right? But in some states, to sell a casket, you have to be a licensed mortician, which involves years of training of how to embalm bodies, how to handle cadavers, right? How to treat people with respect. It's actually very elaborate. So there were a group of monks, I think, who were in Louisiana. The groups of monks in Louisiana, and in their monastery, they made wooden boxes, these beautiful, simple wooden boxes, and they wanted to sell them to raise money for their church. And the government said, "Sorry, you're not morticians. You can't sell wooden boxes." They weren't handling dead people; they were just selling the boxes. You want to know why? Morticians will rip you off. Sorry, I shouldn't say it too loudly, but it's true. If you ever dealt with a funeral parlor, you're at your worst moment, and they will charge you what they want to charge you. I'll give you another one: hair braiding. Right? Hair braiding. To be a hair braider, some states require you to get a cosmetology license, even though cosmetology licenses don't have any classes in hair braiding. Eyebrow threading, which I've never had, but people have done, right? It's a thing, they'll thread. You have to get a cosmetology license to be an eyebrow threader. There's no training about eyebrow threading and cosmetology license. So basically, there are these certifications that nearly exist to create competition barriers. That's what they exist for. They have no actual relation to public health. So there are in some cases where they've actually prevailed. So for example, in Texas, the eyebrow threaders won, right? They actually prevailed. So in another state, the casket sellers prevailed. But these cases are far and few between. So to Oscar's question, maybe better if we just said, you lose, but some judges actually will maybe not apply the opticals because they should. Yeah.
This is personal, I guess. How do you feel about the bar?
What about the bar? Oh, I hate the bar. Look, I mean, you are all second-year law students, right? In about a year, you will spend, 4 months of your life and thousands of dollars preparing for an exam that will do nothing to prepare you to be a lawyer. It's less than worthless, right? You will forget everything you learned the second you walk out that bar room. I promise you. I don't remember a damn thing for the bar. I don't. It's about cramming as much knowledge as possible. It's a cartel. It's an awful cartel. I mean, I think there is some minimum capacity to be a lawyer, right? That exists. Graduating here from is probably enough. A number of law schools in Wisconsin, they have what's called diploma privilege. You know what this is? If you graduate from a law school, you get a bar license for passing a law school. I would eliminate the bar yesterday if I could, but now they're changing with this next gen bar, and it's just not very useful. I think it doesn't do very good. But anyway, so you asked my opinion. Again, you have to do it. You'll suck it up. We've been very successful the last couple of years. We've been over 90, almost 90%, which is good. Don't drop. That's on you guys. That's you all. Yes, Aaron.
Why was there virtually no dissent when this was the most extreme case?
The Optical?
Yeah.
Because Roosevelt won. He had appointed 9 of the justices by that point. Right? These were all Roosevelt and Truman appointees. There might have been actually an Eisenhower appointee here too, but by that point, Lochner was so reviled and Holmes was so respected that they basically said, this is it. We are going to reject and bury Lochner dead in its grave. Put it in one of those caskets you can't sell in Louisiana, right? This was a clear repudiation of that entire era. No one thought otherwise. But, you ready for it? I'm just going to give you a preview for next class. Here they say, if a right is not written down, it gets a presumption of constitutionality, right, which can't be rebutted. What about the right of privacy? What about contraception? What abortion? Where does that fit on this chart? So the contradiction is that in the same breath, the court says the optical, and they say, well, there's this right of privacy we kind of like. And yeah, we can't ban birth control. We can't ban abortion. So Lee Optical is like shutting the door on Lochner. They open a crack when they get to privacy cases, not even 10 years later. It's a tension, right? In other words, they said this, but they didn't really mean it. Lochner always comes back to us no matter how hard you try. You can't get away from the bakers. They're just creeping up with us. Questions? All right, let me wrap up with this chart and just go whoop, straight through. All right, so we have these 4 phases, 4 stages, if you will, where the court addresses the due process clause. In the earlier stages, the court applies its presumption of presumption of liberty that can be rebutted. And in Lochner, Buchanan, and Atkins, the laws were unconstitutional. But in Mueller, they found the government met its burden to show that the wage and hour law for women was reasonable. But then we get to the 1930s, you have O'Gorman, Nebbia, and West Coast Hotel that applied a presumption of constitutionality, where the burden was on the challenger. And they found that these laws regulating insurance contracts, the price of milk, and the minimum wage for women were reasonable. Carolene Products, in its famous footnote 4, qualified the presumption of constitutionality and explained that when you had laws affecting the Bill of Rights, when you had laws affecting the political minorities, these political process, you can still use presumption of liberty. But Lee Optical shut that door shut. They said, you know what? No more. If there's an economic right of contract, government, you're going to win. Congratulations. We're not going to bother litigating the issue. Whew. Okay. Questions? All right. There's Chick-fil-A downstairs. I'll see you guys in a bit. Thank you. Bye-bye.